Okay, now we're moving on to Note 13, which deals with creditors' rights and debtors. A creditor is someone who is owed a legal obligation for payment. Usually that means payment in money, although it could be in other things. And a debtor is someone who has a legal obligation to make payment to another. This is a little bit varying off of what we would traditionally look at when we're talking about business organizations. However, every business, every corporation in the world at some point in time ends up borrowing money or loaning money, sometimes doing both at the same time, so they end up being creditors, debtors, and it is helpful if you're a business person have some basic ideas as to how our system of debt collection and repayment of loans and judgments and other type situations functions. Okay, first thing we're going to talk about is a lien. A lien is a claim against the property of another for the payment of a loan or a debt. And there are several types of liens. There are liens that happen by operation of law, and particularly these are what are called mechanics liens or artisans liens. If you have repairs done to your house, have work done in your house, have improvements made to your real estate, if you have your car repaired, if you bring your watch to a jewelry shop to be repaired, you are creating a debt. You will owe money for the services that have been provided. If you fail to pay the agreed upon price or a reasonable price for those services, then one of the things that happens under the common law, and in Rhode Island this has been reinforced at least for mechanics liens on real estate by statutory law, is that the person who provided the services and goods now has a lien on the property. And they can do different things to perfect that lien, to make it part of the public record, so that, particularly with real estate, you would not be able to buy or sell or refinance until that lien was taken care of. With personal property, generally they have the right to hold on to the personal property until payment for the services has been made. Usually, I won't say usually, but it takes court enforcement to actually carry through on the lien to have the item sold for payment of the debt, which would ultimately happen if you refuse, even if the lien has been placed on the item of property, if you still refuse to pay. The ultimate thing that the creditor can do is go to court and get permission to sell the property to be paid for what is owed. And you would end up losing your rights to the property in that case. There are judicial liens. If you're involved in litigation and it looks like there may be a significant judgment that will come down against you at some point in time, the party seeking that judgment can ask that your assets be held or frozen by the court. This type of lien is specifically called an attachment. It can only be placed on property by the court as a result of a court order. Now, if you went back to the time when I was in law school, you could obtain an attachment ex parte, which means that you did not have to notify the other side. You could go into court, see a judge, often in chambers, explain to them why you thought you needed to get a hold on someone else's property. Usually it would have to be part of beginning a lawsuit, but you would not even have had to serve the person yet. And the judge could, on his or her own signature, create a lien, sign an order that could be placed against the property, which would prevent the owner of the property from selling it, refinancing it, sometimes even using it. There were a number of consumer rights cases that came down in the late 1970s and basically said that these types of proceedings are unconstitutional unless there is notice to the other party and there is a reasonable opportunity for the other party to be heard to make their case as to why an asset shouldn't be tied up. So today, the practice is that in order to obtain an attachment on property, prior to a final judgment being rendered in the case, there must be a hearing. And there must be notice to the other side, to the person who owns the property, that this hearing is happening. They have the right to defend themselves at the hearing. But more importantly, the person who's seeking the lien must show that, number one, they are likely to prevail, that it looks more likely than not that they are going to win the case, that the person on the other side of the case's finances are somewhat limited or somewhat difficult, or that there are few connections to the state, to this jurisdiction, and there's a risk that this property, if it's not real estate, could disappear, or if it is real estate, that it could be sold or mortgaged to such an extent that when a judgment finally came down, there would be no value there for the plaintiff to get to satisfy the judgment. And then thirdly, there are whole classifications of property that are exempt from attachment. Wedding rings, your personal clothing up to a certain amount, a car up to a certain amount, IRAs, 401ks, Social Security payments, and even savings derived from Social Security payments. All of these things and a whole list of others are exempt from attachment in Rhode Island. So even if you have a perfectly wonderful claim against somebody and judgment is going to be forthcoming, you cannot attach these things in advance. All right. It is difficult today to get an attachment. Certainly if there is insurance involved in the case, which a jury would not be told, but a judge would have the right to know and would be found out through discovery. Very rarely will you get an attachment because in all likelihood the insurance will be there to cover the loss and to pay the plaintiff if the plaintiff prevails. So there are times when you can still obtain a pre-judgment attachment, but they are rare and they are difficult, and you'd better have done your homework if you bring such a motion in the court. The judges are not particularly fond of these or open to these at this point in time. There is something called garnishment. Garnishment is actually going to a person's employer and having the employer ordered to hand their wages over to the creditor. So the debtor, the poor debtor, would have money actually taken out of their paycheck to pay this claim. Now, under federal court regulate rules at this point, federal court decisions requiring notice and the opportunity to be heard, and under state and federal regulations, garnishment can only be imposed post-judgment. So you would have already had to go to court against the debtor, you would have had to have won your case, and you'd have to be holding a judgment in your hand from a competent court of jurisdiction saying that you have the right to be paid X amount of money. Only after that point can you seek garnishment. And again, in order to obtain a garnishment, under the present rules, the debtor must be given notice, they must be given the opportunity to be heard. There are federal regulations, there are state regulations that say you can only take a certain percentage of a person's wages, and there is a certain amount which you cannot take, which they are allowed to have so that they have money to live on. You cannot go in and grab their entire paycheck week after week to get paid for the judgment that you're holding. Another situation is called an execution. After a court hands down a judgment saying that plaintiff A is entitled to $10,000 in this case as damages, the judge has little further action involving that unless things get really out of hand and really difficult. But what happens at that point is the clerk will issue something called an execution. An execution is an order to the sheriffs and the constables of the state or the Commonwealth to go out and to find assets of the now judgment debtor that they can seize in order to have this judgment paid. Again, these are only issued after a judgment in the main case has been handed down. You are not allowed to use self-help. You cannot take the piece of paper and go yourself to try and collect the money. You must put it in the hands of a sheriff or a constable and allow them to, on behalf of the court, to go forward to seek payment. There is also something called trustee process. This is where money is in the hands of a third party. So you have a creditor, you have a debtor, and we discover the debtor has a bank account with $30,000 in it. Now again, these are in Rhode Island almost exclusively post-judgment at this point in time. So you've already had a judgment against this debtor. The sheriff has gone out and served the execution, and still there's no payment. The debtor's claiming there's no money, and you determine that they have a bank account with one of the local banks. One of the things you can do is you can again go into court and you can seek to get an order against that bank, where number one, first they have to reveal if they're holding any funds of the debtor or not, and then number two, if they are holding funds, they must pay those funds over to the court for the court to determine where they should go. They cannot release them back to the debtor. Right? Now, if you're dealing with real estate, if your company deals with real estate and borrows money, you're going to enter into the world of mortgages. And of course, we talk about this extensively in the course on property and estates, but for our purpose here, we should make you familiar with a few things. A mortgage is a voluntary lien, it's a consensual lien. It is one of the requirements if you borrow money and you own property. Very often the lender, the bank, will require that you give them a lien on the real estate so that if you do not pay the debt back, they can again sell the real estate to get their money back. It doesn't matter what type of loan or what type of debt the mortgage is securing. I have actually had situations where we have had people execute mortgages to secure divorce judgments where they owed the ex-spouse certain amounts of money, couldn't pay it immediately, so we have them sign a mortgage over to their real estate to ensure that at some point the spouse will be paid what is owed to them under the court order from the divorce. If you do not pay, if you do not fulfill your obligations under the mortgage, then under Rhode Island and Massachusetts law, the right of the creditor is to foreclose. Foreclosure means that you hold a sale, you sell the property, you take whatever is owed to you plus interest and fees. If there's anything left, you give it over to the debtor or to the next creditor in line who might hold a second or a third mortgage. In both Rhode Island and Massachusetts, these are not judicial processes. There must be notice given, there must be opportunity for them, the debtor, to contest the amount of the debt. But once you've gone through all the procedural requirements, you do not need a court involvement here. You basically call an auctioneer, a licensed auctioneer, and you hold an auction on the property, and the property is sold. Now, in many jurisdictions, there's something called a right of redemption after a mortgage foreclosure, which means that even though you lost a house at foreclosure, if you can come up with money in a certain amount of time, your rich great aunt feels badly for you and is willing to pay to get your house back so you're not on the street with your kids. You can now go to the creditor and you can hand them the money that's owed and force them to deed the property back to you. This is not, I repeat, this is not the rule in Massachusetts or Rhode Island, nor is it the rule in any New England state that I know of for mortgages. So that once the auctioneer goes to the auction and they take their hammer with a gavel and go on, it's sold, this is done, it's over, it's final. The next thing you will be receiving is an eviction notice from whoever purchased the property at the foreclosure sale. Now, having said that, also be aware going forward, a little bit far afield from our stuff, but still important to know, if your property is sold for taxes, if your real estate is sold because you failed to pay the taxes on it to the town or the city, there is a right of redemption. And that right of redemption is mandatory for the first year. So whoever buys at the tax sale has to wait a year to see if you're going to redeem or not. And even after the first year, if the person who purchased that tax sale does not go to court in an attempt to wipe out your right of redemption and to settle title to the property, right up until the point, again, where the court enters a decree saying the right of redemption has been dissolved, you have the right to walk into the court with the amount of money owed at that point, pay it, and you have the absolute right under both Rhode Island and Massachusetts law to get your property back. A short sale. What happened in the last economic fiasco in 2008, 9, and 10 is that many people bought properties at the high end of the market, took out huge mortgages, and then the prices collapsed. In parts of Rhode Island, some of the cities, older cities, prices collapsed by almost 60%. So people were in situations where they had a piece of property and it had a mortgage, and the mortgage was for an amount far higher than the value of the property at this point in time. The folks could let the property go and be foreclosed on. But one of the things that happens in Rhode Island and Massachusetts in foreclosures is if the lender does not get all their money back from the foreclosure, then they can go to court, seek a judgment for the balance of what's owed to them on the promissory note or the contract or other agreement, whatever was secured by the mortgage, and then they can, if they get a judgment, they now have 20 years to chase you up and down the country to get paid on that judgment. Also, when properties go into foreclosure, they tend not to, at foreclosure sales, the prices that are bid for them tend not to be the best market prices, the best situations. Don't control what's happening. So a system began to evolve. It existed a little bit prior to that, but it really came into play big time during the 2010 real estate crisis. And it was something called a short sale. And a short sale is a situation where you put the house on the market, you put it up for sale, and you find out that you have a $300,000 mortgage, but the best price you can get for the house is $280,000. So you have a $20,000 hole. Now, having a $20,000 hole is way better than having a $300,000 hole, even from the bank's perspective. If they've sold this property at foreclosure, it's only going to get $280,000 on the open market. Chances are they're going to get far less than that at a foreclosure sale. Or what happens very often is no one bids at a foreclosure sale, particularly when economic times are bad and lots of properties are being foreclosed, and the bank ends up owning it. The bank bids in itself at the foreclosure sale. There are very strict federal rules about this, so the banks end up bidding in at the whole amount, so they end up wiping out the debt, meaning they're not going to get paid on anything, they're just going to have to take the property. Then they have to manage it, pay insurance on it, pay maintenance fees, pay taxes, pay a real estate agent to try and sell it. All in all, it tends to be a losing proposition for the lender. So the lenders and the debtors' attorneys began to work out something called a short sale. And a short sale is a situation where, again, you have a house, you owe $300,000 on it. The best price you can get for it is $280,000. You're $20,000 short. Rather than going through all the expense of foreclosure and then ending up owning the property when they don't want it and still not getting their $300,000 paid back, the bank can agree to release the lien on that property in exchange for a short amount, in exchange for the $280,000 that the buyer is willing to pay. In this situation, the property is the lien, the mortgage is lifted from the property at the closing. The property is allowed to be sold to the new buyer. $280,000 of the debt gets wiped out. There's still $20,000 that hasn't been paid, and different things would happen depending on the bank, depending on the person, depending on the situation. In many situations, the bank would just wipe that out. They would forgive that debt, and the debtor would not have to pay it. In other situations, they would enter into another agreement giving the debtor a certain amount of time to pay that. Trust me, the amount of interest and fees that accrue and the amount of the monthly payment on $20,000 is way less than on $300,000. So very often the debtors were happy to enter into these types of scenarios. One thing you need to be aware of going forward is that if you borrow money and you don't pay it back, and the lender, the creditor, forgives that debt, the IRS regulations and the tax code says at present that forgiveness of debt is actually income to you, and you will owe income taxes on it. The theory being that when you borrow money with a legal obligation to pay it back, it is not income because at some point it has to go back to its original owner. It's only yours to use, not to keep forever. However, if the creditor forgives the debt, they now have put money in your pocket. And of course, when people put money in your pocket, the federal government says, this is income, we want our taxes. Now, during the housing crisis of 12 years ago, the federal government changed the law so that for most homeowners of a moderate home, large chunks of the debt could be forgiven by the bank, and it would not be considered as income to them. But particularly if you have business debts and your bank decides you get into trouble, you can't pay them, and your bank says, oh, we're going to be good guys, we'll forgive them, they will become income, and at some point the IRS is going to come looking for payment on that. The bank has to file 1099 forms showing that this money has been released by them not requiring it to be repaid. And once that goes into the system, at some point in time, if you don't file, admit that you owe, and make some attempt to pay, the IRS will show up at your door or in your mailbox or on your phone saying, we have a small issue with you that we need to discuss. Okay, moving on to something called suretyship and guarantees. If you agree to be a surety, which is the legal name for a cosigner, it means that you are agreeing to pay the debt of another if they do not pay. You can only be forced to do this if you have signed something in writing. This falls under the statute of frauds, both the ancient statute of frauds that we got from England and the more modern versions of it. So you can never be deemed to be a cosigner just by a verbal statement. You actually have to have signed paperwork saying that you agree to cover this debt if the primary borrower does not cover it. In both Rhode Island and Massachusetts, a cosigner or somebody who agrees to be surety, they are primarily liable, which means that the creditor does not have to go after the primary debtor first. If they are not getting paid, they can come right after the person who is the surety. This is somewhat different from many other states, where other states have requirements that the creditor has to show that they first went after the debtor who actually got the money, and only after they have made diligent efforts to collect that debt can they then turn and go after the surety or the guarantor or the cosigner. In Rhode Island and Massachusetts, if you sign as a cosigner, you are signing as if you are a principal on that loan, and the bank doesn't even have to chase the person who really got the money. They can just decide to come after you when they're not being paid. And of course, in the modern world, this is a very difficult thing to do. You should try to avoid it at all in all circumstances, because this goes on to your credit. So even though you didn't get the money, the debt is going to go onto your credit report and be part of your credit rating. It's going to limit how much more money you can borrow. And certainly if the primary borrower starts finagling and not making payments and creating other issues, all that's going to get reported to the credit bureau, not just on his or her credit report, but on yours as a surety also. I run into situations all the time where people have co-signed loans for their children. A very, very bad thing to do. For some reason, children seem to have less worry about paying back when their parents are faced with the debt than if it's a third party that they're somehow injuring or getting in trouble with. So, again, if you sign as a cosigner or a surety in this part of the world, you are effectively another principal on the loan. Now, particularly in business, and particularly where many of our businesses are in closely held corporations, do not have a lot of assets. The whole purpose of the business model was you take out assets as income, as profits, as wages, and you get that over to your private ledger. And so that way, if the company gets sued or runs into contractual problems or problems with their debtors, the only assets that are theoretically are online are those assets of the corporation. However, bankers have been here for a long time. They are probably been here before there were attorneys, and they are not dumb. So if you have a small corporation, if that corporation is not heavily capitalized, does not have property that can be used to place a lien against, then the banks will happily lend to your corporation, and they'll lend in the name of the corporation, but they will ask the principal parties to become guarantors, to sign something called a guarantee. And in this situation, a guarantee means that you will step in to make payment if the primary party does not pay. Now, under guarantee law, the old rules still exist to a great extent, so that they would have to go after the corporation first and make diligent efforts to collect from the corporation, and only after that point could they come against the guarantor. But in many of the guarantee agreements that I've seen written for my clients lately, the banks are getting around that even by putting language in saying that the guarantor waives the right to have the bank go after the corporation first. So just know that even though you've gone to great effort to set up this two-tiered system where there are corporate assets and your assets, that will protect you against torts and certain other types of things. But when it comes to borrowing money, the banks have got this all figured out, and they're going to make you sign as a guarantor for your corporation so that you will become responsible if the company does not have the money to pay. Um, Sureties or guarantors can end up being released unintentionally if the lender agrees to modify the underlying loan, particularly if they increase the interest rate or they increase the amount owed without getting something in writing from the surety or the guarantor, they would be excused certainly to the extent of any increase and possibly even to the whole debt. Um, if they surrender collateral, now very often banks and loan companies and creditors, they will hold, particularly if it's personal property, they will hold collateral. Or even taking a mortgage on real estate or a lien on a car or something. If they surrender that to the debtor, then they may be releasing the surety or the guarantor, because one of the reasons that a surety or guarantor would enter into this agreement is that, well, they've got the house to go after. Even if Harry doesn't pay, they're not going to come after me because they're going to go after the house. So if they release the house to Harry without getting the debt paid, and then Harry stops paying, one of the defenses for the surety and guarantor would be, wait a minute, they substantially changed the loan terms. They put me at far greater risk than what I signed up for here. And certainly, payment or an offer of payment by the debtor, if it's refused by the lender, by the creditor, that releases the guarantors and the sureties. Now, guarantees and sureties have certain rights against the debtor. They have a right called subrogation. If they end up having to pay the creditor, then they become the creditor. Now they can chase the debtor to be paid by the debtor. They have the right to reimbursement. So if they had to hire attorneys, if they had to do different things in order to protect themselves from collection, then they have the right to go against the principal debtor for those. And they have the right to contribution. If there's more than one guarantor, more than one surety, and one ends up being chased by the bank, hunted down, and made to pay the entire loan, they have a right to go against the other guarantors and the other sureties to say that they must contribute to help cover their proportionate share of the debt. All right. Under the present law, certainly mortgages are written documents. They are placed in the land, recorded in the land evidence records, and if there is a mortgage on title, it effectively prevents the sale or later or further refinancing of that property until that mortgage is dealt with personal property items. There is something called the Uniform Commercial Code, Article 9, and in Article 9 they deal with secured transactions. And a secured transaction under Article 9 is very much, legally, this is certainly not a correct way to state it, but for a layperson's perspective, it's basically putting a mortgage on a piece of personal property. Now again, when we get into real estate, all property is divided into two broad categories. One is real estate, the other is personal property. And personal property certainly includes equipment, but it also includes contract rights, it includes promissory notes, it includes all promises to be paid, all types of other things. And under Article 9 of the Uniform Commercial Code, a debtor can use these items as collateral, and the creditor has a system. In Rhode Island, it's by filing with the Secretary of State's office. They can file a claim, a security document against these certain things, and basically they now have a lien on that piece of property. So when we're doing business transactions, and it would behoove you, even if you're doing a consumer transaction, buying a piece of used equipment, a piece of used property of fairly high value, $10,000, $20,000, $30,000, we would always check with the Secretary of State to make sure that there isn't a lien on that piece of equipment held by some lender, some debtor, creditor. The security interests, some of them arise the minute the property changes hands. So if a merchant is buying property from a manufacturer on credit, the manufacturer has an automatic security lien in the property until they are paid for the goods. All right. If it is a situation where the debtor is already the owner of property and they're offering it to a creditor as security, then there must be this filing done with the Secretary of State's office, and the filing must be something that is called perfected. It has to actually be created and happen in order for the creditor to have superior rights in this piece of property against other creditors, and particularly against the bankruptcy courts. A security interest can be perfected without filing if the creditor has actual possession of the property. So if the creditor takes the property, all right, you're going to put up your $20,000 worth of jewelry as collateral, just bring that over and we'll keep it in our safe until you pay us back. At that point, the act of possession has perfected the lien on the property. Or, again, as we said, if it's a purchase money security interest, the seller of the goods extends credit for their purchase, then the lien is automatically perfected. Otherwise, paperwork must be drawn up, it must be correctly filed in the proper office, and again, in Rhode Island and Massachusetts, that's with the Secretary of State. Once the lien is created, it's valid for 5 years. If it has not been paid, then within 6 months of the 5-year period, the creditor can file an extension for another 5 years. Right? But they cannot let the 5-year date pass. If they let it pass, then they lose the lien completely. This system only applies to personal property and to fixtures, to personal property that gets attached to a building. Cars, trucks, trailers, recreational vehicles, they have a different process. They are secured through the state titling process. Any of you who have bought and sold cars, if you borrow money to buy the car, you know that you don't get the title to the car until you have paid back the lender. The title goes to the lender, and it actually is issued with the lender's name on it, so you cannot sell the car to someone else or borrow more money against the car because you don't have the title certificate, number one, to turn over, and even if you had it, it lists the other lender as having a priority lien. This is all handled by the Registry of Motor Vehicles in the state, and as long as the initial paperwork is filled out correctly, they take care of this, and we lawyers very seldom get involved in it because it just is kind of a ministerial type process. Boats can be secured either by a state title, or there is a system that the Coast Guard has for filing liens against boats on a federal level. Now, the UCC allows a large range of items to be subject to a lien. Certainly, basic things like equipment, inventory, but even receipts payable, proceeds from the sale of secured property. So if you manage to sell the property and it disappears somewhere, whatever money you got for the property, the lien remains on that property. There are times when, particularly if you're a merchant dealing in the buying and selling of goods, so there is a constant flow of goods coming in, goods going out, the security agreement can be written in such a way that the lien applies to after acquired goods. So as your inventory keeps constantly changing, the lien keeps jumping from each new piece of inventory to another piece of inventory, and when you sell a piece, there are provisions for it to be released to the consumer, so the consumer is not subject to it. All right. There are liens against future advances. All right. So you can word the agreement, and this is true of mortgages today too. Traditionally, a loan was for a set amount of money given at the specific time the loan was made, and whatever security you had was only for that amount. In modern business, we found that to be very constraining. So with both real estate and personal property, you can write up documents, loan documents now, that basically create a line of credit so that you can be going back to the creditor asking for more money for further advances, future advances, without having to redo all the paperwork and basically without having to have a new closing. Home equity lines often work this way. Certainly credit cards work this way. The balance can go up and down. You can draw up and down to a certain amount. And we can even have business loans that work that way, so that the amount of the lien actually can vary from time to time and can go up and down with whatever advances are being made. You can have something called a floating lien, where the lien basically follows the debtor, and whatever property the debtor owns at the moment, the lien is on that property. This particularly is applied again in industries where valuable items tend to change hands very quickly, just as part of the normal process of doing business. The whole goal here is to have priority, because very often, if a debtor is getting in trouble, they don't owe money just to one party, they owe money to multiple parties. And our basic legal system, certainly in real estate, but even in personal property, the basic ideology for 1,000 years has been first in line, first in right. With real estate, it's very easy to know who's first in line. You go to the registry of deeds, and whoever filed first, they are first in right. But the same thing comes into play here. Whoever acquired perfection first, they have the superior rights to the collateral to take that property and sell it to get their debt paid first, and whatever is left over, then they can give to the second and third and fourth tier creditors. All right. Perfected creditors have first right to take any property to cover what they are owed. They prevail over all third parties who came later. They prevail over parties who may have been there first but failed to properly perfect their lien, and they certainly prevail over creditors with no lien. If there is a conflicting perfection, so two people have perfected their liens, the basic rule again is first in time, first in right. All right? The first person perfecting the claim gets the entire property. They don't have to share it with the second person perfecting. Parties who are later in time have to hope that the assets are so valuable that after the primary secured creditor gets paid, there's something left to spill over to them. Unsecured, unperfected parties, people without liens, are paid last, and they are usually only paid a percentage of what they owe. By the time we get down to them, there's usually nothing left or very little left, and very often, if you end up in bankruptcy, all the unsecured creditors, unperfected creditors, end up as a pool, so there is no first, second, third at that point. Everybody shares proportionally their losses at that point. There are exceptions to the priority rules. The basic, most important one of these is a buyer in the ordinary course of business, or a BFP, a bona fide purchaser. If you as a consumer walk into a big box store and buy a $5,000 TV set, you pay consideration for it, the transaction is normal, above board, even though that TV set may have been given to big box store by the Japanese manufacturer, the Chinese manufacturer on credit. You, as the ultimate consumer, are deemed to be a buyer in the ordinary course of business. You take that item home free of any lien, and it's now between the manufacturer and the big box store company to fight over how the manufacturer is going to get paid, how much they're going to get paid, what's going to happen. All right. This is the only way that we can buy items without constantly having to go to the Secretary of State for every single item and check to see if there happens to be a lien on it or not. So this is a very important rule. It protects the consumer. All right. Again, this idea of purchase money security interest. So even if a lender had loaned the company $1 million, said we have a floating lien, we have a lien for future acquired property that covers all stock, all inventory. If I, as a manufacturer, send you goods on credit, 30 days payable, 90 days payable, whatever, because that was a purchase money loan, I have a priority lien over the liens of other creditors who may have been there long before I came along. All right, some of the rights and duties of debtors and creditors. Both parties have a right to a copy of the recorded financial statements. The creditor has the right to assign or sell this debt to a third party. And very often, if you have gone into debt, if your debts have gone into collection, suddenly you find out you're not dealing with a nice representative at your local credit union anymore. You're dealing with a miserable, awful, horrible group of people at a collection agency. And this is because debts can be freely bought and sold. There is a market for these things. It's often a discount market, so once you have defaulted on the payments, the loan is not worth its full face value, but somebody will buy it for a lower value and then attempt to collect the full amount plus interest and penalties and fees from you. The only way to stop this is to, in the agreement, say that this cannot be done. No commercial lender will give you money if you want to put that in an agreement. All right. Parties can agree to amend a financing statement if terms or conditions change, but the amendment will still preserve priority. All right. And a debtor has a right to an accounting and a confirmation of an outstanding debt. So if you are being chased by somebody for a debt, particularly something that you thought had disappeared 20 years ago and all of a sudden it's come up and they're chasing you, under federal law at this point and under parallel state law, you have the absolute right to demand proof of the debt. Where was it originated? Who was it originated with? How many payments were made against it? Why do you say I still owe money on it? And if the creditor cannot do that, then they cannot bring suit against you to collect on that debt. When the debt has finally been paid, the debtor has a right to have a termination statement filed in the records. And a termination statement is basically something that says, oh, yes, there was a lien, it's been paid, we no longer hold any rights. All right, default. Default is the failure of the debtor to fulfill their obligations under the security agreement or promissory note or loan agreement. The most common form of default is failure to make payment. However, there can be other types of default. Failure to preserve the property that the lien is on. In commercial loans, there are always requirements today that the business provide annual reports, copies of tax returns, copies of bookkeeping, inventory lists. Failure to file any of that with your lender in the appropriate time can be a default. All right. Unlike in consumer situations and unlike in landlord and tenant situations, the creditor may have the right in commercial situations to self-help. The UCC provides that a creditor may seize secured goods without court process so long as it is done peacefully, without trespassing, without violence or the threat of force, and without breaking and entering. Upon taking possession, the creditor can keep the property or can sell it to get funds towards whatever they're owed. They also can always pursue a judicial remedy, which is where they go into court to sue on the debt that's remaining, or even to go into court to ask for a court order to seize the property. When the secured property is taken back by the creditor, what can they do? They can keep it, they can lease it, they can sell it, they can dispose of it in any commercially reasonable manner. If they are keeping the property, they must give notice to the debtor and to any junior lien holders who may want to contest their keeping the whole value of the piece of property. If sold proceeds are dispersed, then they are broken down as follows. The primary creditor, the secured creditor, gets principal, interest, costs, and legal fees. Those could include legal, court fees, moving fees, storage fees, auction fees. The junior lien holders who make a written demand are paid next. Any surplus goes to the debtor. If the proceeds are insufficient to pay the secured party, then they and the other debtors can seek a deficiency judgment. They can still sue the creditor. If any of the if the proceeds are insufficient to pay the secured party or other creditors, then they can still go against the debtor in court. Again, certain states have a right of redemption. It allows a debtor, if they come up with money, particularly prior to a sale, they can redeem the property and get it back from the creditor. All right. That pretty much ends our discussion of Note 13. We will see you in Note 14.